I used to think that loyalty ran deeper than money in a family. After spending 8 years watching my husband Frank lose himself to Parkinson's disease, one trembling step at a time, I believed that kind of devotion left a permanent mark on the people who witnessed it. What a generous fiction that was. The morning I discovered my son-in-law Craig had taken out a $340,000 second mortgage against my home, without my knowledge, was the morning I understood that some people watch sacrifice and see only an opportunity. I want to be clear about something before I go any further. I am 63 years old. Before I became Frank's caregiver, before I became a grandmother who bakes lemon pound cake and tends a garden that wins the Millhaven Beautification Award 3 years running, I spent 22 years as a vice president of lending at Cornerstone Regional Bank. I underwrote commercial loans. I structured debt. I understand exactly what a deed of trust looks like, what a notary signature block requires, and what it means when a document bears a signature that does not belong to the person whose name appears beneath it. Craig forgot that part. They all did. Frank died on a Thursday in October, 12 years ago, in the bedroom we had shared for 31 years. Our 3 children were there. Dana, our eldest, sat closest to him, holding his hand with her husband Craig standing just behind her, one palm resting on her shoulder. Marcus stood near the window, quiet the way he had always been quiet since boyhood. Liam, our youngest, sat on the floor beside the bed because there were no more chairs, and he was never the kind of person who asked anyone to make room for him. That image stays with me even now. The 4 of them arranged around their father while I held his other hand and felt his pulse slow and then stop. Frank had been a good man, a high school history teacher who coached JV baseball and drove 40 minutes each way to Millhaven because he loved the town and refused to leave it, even after better jobs surfaced in Columbus. He left behind a modest life insurance policy I had converted into a structured trust after his diagnosis, a fully paid home on Birchwood Lane, worth more than either of us ever imagined when we bought it in 1989, and a lake cottage up at Cedar Point that he had spent every summer weekend of his adult life repairing, improving, and loving. Combined with the trust accounts and a retirement portfolio I had continued growing through careful management, the estate totaled just under $1.4 million. Not a fortune by anyone's measure, but a life's work made solid. I remained the sole trustee. Frank and I had agreed on that before his mind became unreliable, sitting across from our estate attorney Gerald Marsh on a clear afternoon in April, while Frank could still hold a pen without shaking. He had looked at me across that conference table and said, without any ceremony, "You know more about this than I ever did. I trust your judgment completely." Gerald had nodded. I had signed my name. For 11 years after Frank's death, nothing happened that suggested my judgment would ever be questioned. Then Craig lost his contracting business. I did not know the full extent of it until much later. What I knew, in the winter of that 11th year, was that Dana had grown quieter on our Sunday phone calls, that Craig had stopped joining her when the family came for holidays, and that my daughter had developed a habit of steering every conversation away from money, finances, property values, or anything within several degrees of the topic. She was not subtle about it. Dana had never been subtle. She came to Frank and me the same way she approached everything in her life, with her whole heart visible in her face, which made her easy to love and easy to deceive. The first sign came at Thanksgiving. Craig arrived with a new energy I could not immediately name, attentive in a way that made me feel observed rather than cared for. He refilled my wine glass without being asked. He complimented my cooking with a specificity that felt rehearsed. After dinner, while Dana helped me with dishes, Craig sat with Marcus in the living room, and I heard my son laugh at something, heard the low, comfortable register of 2 men agreeing about something. I heard the words mom and alone and property taxes in a sequence that tightened something behind my sternum. I said nothing. I dried the plates and listened. 2 weeks later, Dana called and asked if I had thought about moving somewhere smaller. I let a beat pass before I responded. "Where is this coming from?" She stumbled through the answer. "Craig and I have been talking. That house is enormous for one person, Mom. The maintenance alone, the heating bills in winter. We just think you would be happier somewhere more manageable." "I have managed just fine for 11 years, I said. She pivoted quickly, the way people do when they are reading from a mental script. "Craig's cousin owns a beautiful over 55 community over in Delwood. Independent living, a pool, Organized activities. He put in a good word. They have an opening. Craig's cousin. I set my dish towel on the counter. Did Craig ask you to make this call? Silence. Then, Mom, we just want what's best for you. I told her I would think about it. I put the phone down and sat in Frank's old armchair in the study for a long time, my hands folded in my lap, running through every financial conversation I had allowed Craig into over the past 3 years. A question about the trust structure here, a casual comment about Cedar Point's property value there, the time he had asked, with remarkable offhandedness, whether the house would transfer directly to the children or go through probate. I had thought nothing of any of it at the time. Craig was family. Craig was curious. Craig was making conversation. I called Gerald Marsh's office the next morning. Gerald had handled Frank's estate and had known me through the bank for 15 years. When I explained what had happened, he did not immediately reassure me. He paused the way good attorneys pause, not from uncertainty, but from care. He said, "Let me pull the public records on your property and call you back this afternoon." He called back in 2 hours. "Eleanor," he said, and I knew from the way he said my name that what came next would not be simple. "There is a second deed of trust recorded against Birchwood Lane, filed 8 months ago. Lender is a private equity firm out of Indianapolis, $340,000. I sat down. "My signature is on the documents?" "Your name is on the documents. I cannot confirm your signature without seeing the originals." I drove to Gerald's office that same afternoon. He had printed the filing from the county recorder's website. I studied the signature block for approximately 4 seconds before I set the paper on his desk and said, "I did not sign this." Gerald looked at me steadily. "I believe you. I have not refinanced, not borrowed against this property, not spoken to anyone at this lender. I would never take on debt at this stage of my life, for any reason. Frank and I spent 30 years paying off that house." He nodded. "Then someone signed your name." We sat with that sentence in the room between us. "The question," Gerald said eventually, "is who had access to your personal information? Your social security number? Your date of birth? Enough documentation to convince a private lender to fund a loan." He paused. "Do you have any ideas?" I thought about Craig's question the previous Christmas, asked so casually while we were clearing the table, about whether I kept my important documents at the house or in a safe deposit box. I had told him both, smiling, because I was his mother-in-law and he was making conversation. I told him Frank's study had a fireproof cabinet and that the bank box held duplicates. I even told him which branch. I told Gerald everything. That night I called Liam. My youngest lived in Cincinnati, working for a software company, and had always been the child most likely to answer his phone before the second ring. I raised 3 children very differently from one another. Marcus had Frank's steadiness, but also Frank's tendency to defer to whoever spoke with the most confidence in a room. Dana had my stubbornness, but Craig had spent 11 years redirecting it. Liam had inherited a combination of Frank's ethics and my analytical wiring that had made him an occasionally inconvenient child and was now making him an invaluable one. I told him about the mortgage. I told him about the Thanksgiving conversation and Dana's phone call. I told him about Craig's questions over the past several years, rearranged now in chronological order, and I heard my son go very quiet on the other end of the line. "Mom," he said when I finished, "how long do you think this has been planned?" "I don't know yet. But I'm going to find out." "I need to come home," he said immediately. "You have work." "I'm coming this weekend." He paused. "Don't confront Craig yet. Don't let them know what you know." I told him I had spent 22 years in lending, that I knew how to hold a face still when I was reading a bad loan file. He laughed, which was the first laugh I had managed to pull out of anyone that day, and we said goodnight. Gerald spent the following week requesting the original loan documents through proper channels and consulting with a colleague who specialized in elder financial fraud. The term landed in my chest with unexpected weight. Elder financial fraud. I was 63 years old and walked 4 miles every morning. I served on the advisory board of the Millhaven Public Library. I grew heirloom tomatoes and corresponded with my former colleagues about commercial real estate trends. But the law recognized what I was in relation to someone like Craig, and the word applied. Liam arrived Friday evening, drove straight from Cincinnati, and sat across from me at the kitchen table with his laptop open and a yellow legal pad beside it. He had the same focused expression Frank used to get when he was grading papers he cared about. I made coffee and let him work. "Mom," he said after about an hour, "Craig's business dissolution was filed 14 months ago. He has 2 civil judgments against him in Indiana, one from a subcontractor, one from a materials supplier. Combined, they're just under $90,000. I absorbed that. Dana doesn't know. I don't think she knows the full extent." He turned the laptop toward me. "He also has a credit inquiry on file from the same private equity firm that holds your mortgage, from 6 months before the loan was recorded. He was in contact with them before any documents were signed, so he identified the lender first, then created the documents. That's what it looks like." I thought about my daughter, Dana, sitting across from me last Easter, her face tired in a way that I had attributed to the season, to the busyness of her work, to the ordinary grind of a marriage in its middle years. Had she known? Was she protecting him? Was she afraid of him? I did not know, and I realized I needed to understand the answer before I decided anything. I called her on Saturday afternoon, while Liam sat in the study reviewing more documents and Craig, I knew, was at a friend's house watching a football game. "Dana," I said when she answered, "I need to ask you something directly, and I need you to answer me honestly." She said okay, the way people say okay when they are already afraid of what comes next. "Did you know Craig has been having serious financial problems?" The pause lasted long enough to tell me that she had. "How much do you know?" she asked finally. "His company dissolved over a year ago. He has judgments against him. And there is a mortgage against my house, Dana. $340,000 that I did not agree to and did not sign." The silence on the other end of the line was the kind that has a physical quality, a held breath, a fist closing. "Mom," she started. "I am not angry with you right now," I said, keeping my voice even. "But I need to know what you knew and when." She told me, in the halting way of someone confessing something they have been carrying for a long time, that Craig had come to her 8 months ago and said he had found a solution to their financial problems, that he had structured a loan through a business contact using a property he had access to as collateral, that he had told her I had agreed to it, that she had wanted to ask me, but Craig had said it would embarrass me to discuss it directly, that I was proud and old-fashioned about money, that he would manage everything and I would never need to worry. I had agreed to it. He told her I had agreed to it. She began to cry. "Mom, I'm so sorry. I should have called you. I should have asked you directly. He said. "I know what he said," I told her. "Dana, what Craig did is a crime. I need you to understand that clearly. Forgery of a loan document is fraud. It doesn't matter that he is your husband. It doesn't matter that he thought he was solving a problem. He committed fraud against me." She was crying harder now. "What are you going to do?" "I am going to do what needs to be done. And I need you to decide whose side you are on, not to punish you, but because what comes next is going to require everyone in this family to be honest about where they stand." After I hung up, I sat very still for several minutes. Liam appeared in the doorway with 2 mugs of coffee and set one in front of me without a word. I told him what Dana had said. "So she was deceived too," he said. "Yes. And she let herself be deceived because it was easier than asking me directly." He nodded, his expression careful. "What do you want to do?" "I want to protect my home, my trust, and my ability to make my own decisions. I want Craig held accountable through every legal channel available, and I want my children to understand what happened in this family, so that none of them spend the rest of their lives wondering." Gerald filed a fraud complaint with the Indiana Attorney General's office and the county sheriff on Monday morning. He also moved to void the deed of trust through the county recorder's office, filing an affidavit of forgery, supported by a forensic document examiner who compared Craig's known handwriting samples to the signature on the loan documents. The comparison was not close. Whatever Craig had imagined about his ability to replicate my signature, he had underestimated the specificity of 22 years of professional document handling. Marcus called me midweek. Craig had apparently reached him first, delivering a version of events in which I had agreed to the loan verbally, changed my mind, and was now weaponizing the legal system against him out of spite. My son had the decency to call me before forming an opinion, which I appreciated more than I told him at the time. He said that what Craig had described sounded plausible if you didn't know me very well. I said that was an accurate observation. Then he asked me what actually happened, and I told him, calmly and specifically, the way I used to present loan reviews at board meetings, with facts in sequence and documentation available. When I finished, Marcus was quiet for a moment. Mom, why didn't you tell us Craig was asking all those questions? Because at the time they were just questions. I had no reason to believe they were reconnaissance. He exhaled. What can I do? Tell me honestly whether you believe me. Without any hesitation, he said, Of course I believe you. Then he said he would drive up the following weekend and stay as long as I needed. The legal process moved at the pace legal processes always move, which is to say slowly, with considerable paperwork and periodic developments that arrived without warning on otherwise ordinary days. The private equity firm, once presented with the fraud complaint, cooperated quickly. They had no interest in defending a forged instrument in court, and their appetite for Craig's business evaporated as soon as Gerald's office presented the forensic analysis. The deed of trust was voided within 6 weeks. Craig was arrested on a Thursday afternoon, pulled over on Route 9 while driving back from a hardware store, according to what Dana told me later. The charge was forgery in the first degree, a felony in Ohio. His attorney contacted Gerald immediately and signaled an interest in a plea arrangement. Dana called me the night of the arrest. I could hear in her voice the particular quality of someone standing at a crossroads they have been approaching for a long time without admitting it. Mom, she said, I don't know how to do this. I know, I told her. I keep thinking about the last 12 years. All the times I wondered and didn't ask. All the things I let him explain away. You were loyal to your husband. That isn't a character flaw. But loyalty to someone who is doing harm is something different, and I think you know that now. She asked if I hated her. I told her no, which was true. I told her I was disappointed and hurt, which was also true. I told her those two things could exist at the same time. She cried again, less desperately than the first time. What I did not tell her on that call, what I told her 2 weeks later in person at my kitchen table over coffee, was that I had already begun reviewing the trust documents with Gerald to make changes I had been contemplating since the Thanksgiving when I first heard the word property taxes spoken in that particular tone. What I wanted was not punishment. I had no interest in using money as a weapon, but I had every interest in ensuring that the choices I made with my assets reflected the realities of my relationships, not the assumptions I had made when those relationships seemed simpler. I restructured the trust while the criminal case was still pending. Cedar Point Cottage went into a conservation easement that prevented any future sale, protecting it in perpetuity for family use, but eliminating it as a liquidatable asset. The Birchwood Lane house remained mine until I chose otherwise, at which point the proceeds would establish a financial literacy fund in Frank's name through the county library system, something he would have found meaningful, and Craig would have found useless. The liquid assets were redistributed unequally and with conditions, and I engaged a professional corporate trustee to ensure that no one person in the family would ever control decisions about my estate, independent of oversight. I held a dinner for Marcus and Liam at the house in March, on a Sunday when the first real warmth of the year had arrived and the daffodils along the front walk were just beginning. Dana came as well, alone, and sat across from her brothers with the quiet, careful posture of someone who understood she was present because she had been offered something she had not fully earned back yet. I told them what I had done and why. I told them clearly that the changes reflected relationships as they had actually been, not as I had wished them to be. I told them that love was not diminished by honesty about its complications. Liam said, "Good." Just like that, without ceremony. Marcus nodded slowly and said he understood. Dana said nothing for a long moment, and then said she was sorry, again, and that she meant it more than she had words for. I told her that actions over time would be the measure, not the words, and that I believed she was capable of both. Craig's plea agreement was finalized in late April. He pled guilty to a reduced charge, received 3 years of supervised probation, was ordered to complete 200 hours of community service, and was required to pay restitution of the legal fees and associated costs Gerald's office had incurred on my behalf. He lost his contractor's license. His name was on the public record as a convicted felon. Whatever he had imagined securing by attaching himself to my assets, he had instead secured the permanent end of his professional credibility in a state where he had spent his entire career, I did not attend the hearing. Gerald sent me a summary afterward and I read it at the kitchen table with a cup of tea. Russet, our old tabby cat, arranged across my feet under the chair. I felt what I expected to feel, which was not triumph and not grief, but something more like the particular quiet that follows a long decision finally made. The way a room sounds after you close a window that has been opened through a storm. Dana filed for separation 2 weeks after the plea. She called to tell me on a Tuesday evening, her voice steadier than I had heard it in months. "I am not telling you this to make you feel responsible," she said. "I am telling you because I want you to know first, before anyone else." I told her I was proud of her. She said that was the first time in a long time she had heard that sentence and believed it entirely. That summer, Marcus drove up 6 different weekends with his family. His youngest daughter, my granddaughter Polly, discovered the vegetable garden and appointed herself its official assistant, arriving each time with small gardening gloves and very serious intentions about the tomatoes. Liam came when he could, sometimes just for a Saturday, once for a full week when he was working remotely. Dana came 3 times, always alone at first, and then in August she brought her 2 sons, who were old enough to understand that something in their family had changed, and young enough to adapt to the change with the remarkable elasticity of children who are loved steadily and well. One evening in early September, Liam and I sat on the back porch while the light went golden over the yard, and he asked me something I had been asking myself for most of the past year. "Mom, do you think you should have seen it earlier?" I considered that honestly. "I think I saw pieces of it and chose not to arrange them into a picture," I said. It was easier to believe Craig was simply curious than to believe he was calculating. That was my choice, not my failure. What's the difference? A failure implies I lacked the ability to know. A choice implies I made a decision about what I wanted to be true. I looked at the garden, at the last of the summer zucchini hanging heavy on the vine. I won't make that choice again. Liam was quiet for a moment. "Did you ever feel sorry for him?" I thought about Craig and the specific quality of his desperation. The way a man in real trouble sometimes stops looking like a villain and starts looking like a person who made a series of wrong turns in the dark. I felt sorry for the situation he created for himself. I said, "I felt a great deal of sorry for Dana and her sons, but my job is not to protect Craig from the consequences of what Craig decided to do. My job was to protect myself, my home, and the life Frank and I built together. That's what I did." Gerald called in October with a final update. The private equity firm had pursued Craig civilly for the costs associated with the void instrument, which had added another layer of financial and legal consequence to the list he was already managing. Gerald said it with the mild satisfaction of a man who had spent a career watching good legal strategy produce its intended results. I thanked him. He told me Frank would have been proud of how I had handled everything. I told him Frank would have been quietly furious on my behalf for about 2 days and then would have said we should plant something to mark the occasion. Gerald laughed and said that sounded exactly right. The house on Birchwood Lane felt different that fall in the way houses sometimes feel when the atmosphere inside them changes. Not larger, not smaller, but more accurately itself. The rooms held the same furniture, the same photographs, the same collection of objects Frank and I had accumulated across 31 years of ordinary life together. But they held something else now, too, which was the knowledge that I had stood in this house and refused to be moved from it by pressure, by manipulation, or by the slow, patient erosion of someone's carefully applied doubt. My name was on the deed. My signature was my own. My life was still mine to arrange. That winter, I joined the Financial Literacy Council at the library, the one the trust would eventually fund, and began working with Gerald on the formal endowment structure. Frank's photograph sits on the desk in the study while I do this work, which I do not think is a coincidence or a sentiment. It is simply the correct arrangement of things. He understood money as a tool and a responsibility and a form of care, and so do I. And teaching other people to understand it the same way seems like the most accurate legacy either of us could leave behind. Some evenings I sit in the back porch while the neighborhood settles into dark, and I think about what I thought I knew about loyalty and devotion and the debts we accumulate by loving people for a long time. I think about how much easier it would have been to let myself be moved, to go quietly to the over 55 community in Delwood and let someone else manage the inconvenient complexity of a life I had spent 63 years building. I think about how close I came to allowing someone else's desperation to be mistaken for my decline. And then I think about the morning I sat in Gerald's office and looked at a signature on a document and said, simply and with complete certainty, that is not my name. And I understood in that moment what it means to know yourself well enough to recognize when someone else is trying to be you. It means you do not let them.